5, 4, 3, 2, 1, start.
The respondent accused is alleged to have made an extrajudicial confession before PW6, who ran a scooter repair shop. Full stop. According to PW6, the accused used to visit him to borrow money to buy liquor and drugs, and on 30/11/2003 he visited him in the evening and confessed to having raped and murdered a young girl. Full stop. The respondent allegedly requested the witness to save him, but the latter refused help and informed the police on 1/12/2003. Full stop. However, in cross-examination, PW6 deposed that he had never given money to the accused and that the accused came to his shop asking for money for the first time on that day. Full stop. Chenja. He also deposed that accused was neither his friend nor was he related to him. Full stop. It is further a matter of record that the respondent, according to the witness, was known to him for about 2.5 months before the incident. Full stop. Significantly, PW6 stated that the respondent confessed to his crime in the presence of 5-6 other villagers and their names had been disclosed to the police. Full stop. He further deposed that he did not know the name and address of the accused and had not given this information to the police in his statement. Full stop. However, in his statement given to the police at Exhibit PW6 over DA, the name of the father of the accused and the address of the accused are both mentioned. Full stop. PW6 also deposed that on 30/10/2003 he met Constable Narendra and narrated to him about the confession, and he advised him to go to the police station the next day, that is 1/11/2003, and have his statement recorded by the SHO. Full stop. The trial court reasoned that a detailed study of the evidence of PW6 raised doubts about its authenticity. Full stop. Chenja. The respondent was neither a friend nor a relative of PW6. Full stop. The witness was also not a person in authority to whom someone would go and seek help. Therefore, the basic principles of an extrajudicial confession were inapplicable when the person to whom confession is alleged to have been made is an absolute stranger or a formal acquaintance. Full stop. It was noted crucially that the confession was allegedly made in the presence of 4-5 other villagers. Full stop. Confession by its very nature would not normally be made in the presence of a crowd. Full stop. If a person has to confess, he ordinarily would confide in one person in whom he can repose trust or confidence. Full stop. Confessing before 5-6 people, therefore, according to the trial court, did not appeal to common sense. Full stop. Furthermore, those in whose presence the alleged confession was made and whose names were revealed to the police were not cited by the police as witnesses. Full stop. Although no query was put to the witness, Exhibit PW6 over DA is silent about the names and whereabouts of the other persons who are said to have heard the confession. Full stop. Stanza. Another aspect noticed by the trial court was that PW6 claimed to have informed Constable Narendra about the confession by accused on 30/10/2003. Full stop. However, Narendra could not be located by the IO. Full stop. PW26 deposed that the identity of Constable could not be fixed, to whom PW6 had disclosed about confession of the accused. Full stop. The trial court observed that PW6 had deposed that he did not know the address or parentage of the accused and had not given the same to the IO in his statement. Full stop. However, he was confronted with this statement recorded by IO during investigation, which recorded the father's name as well as the address. Full stop. This indicates an effort by the IO to create evidence against the accused. Full stop. PW6 deposed that his statement was recorded after the apprehension of the accused, that is, on 30/10/2003, whereas the arrest memo of the accused reveals that he was arrested on 3/11/2003. Full stop. Stanza. There was thus a contradiction in the testimony of Deepak vis-a-vis rest of the investigation. Full stop. In view of these factors, the trial court disbelieved the testimony of PW6 regarding the extrajudicial confession by the accused. Full stop. Conduct of the accused in remaining absconding. Full stop. The trial court refused to give weightage to this factor, observing that there was no evidence to indicate that police party had taken steps to arrest the accused on any date before 3/11/2003. Full stop. On 3/11/2003, he was arrested from outside his house, and therefore the argument that he was absconding did not apply. Full stop. On this aspect, the impugned judgment notes that PW25 deposed that on 16/11/2003 the accused refused to participate in test identification parade. Full stop. She proved her report as exhibit PW25/C. Full stop. Therefore, it is established that accused had refused to join test identification parade. Full stop. The accused was held guilty for the offence punishable under section 363 read with 511 IPC in case number 42/2003 FIR number 11/2003. Full stop. Stanza. The prosecution argued, therefore, that the accused was a serial offender who was habituated in kidnapping and raping minor children. Full stop. On this contention, the trial court observed that in the absence of other circumstances indicating the involvement of accused in the present occurrence, such circumstances alone cannot be sufficient to hold the accused guilty. Full stop. The learned APP argued that the trial court misappreciated the evidence, particularly of PW5, who was clearly an eyewitness to the accused being last seen in the company of the deceased. Full stop. It was submitted that the so-called unnatural conduct of this witness is a subjective factor which incorrectly crept into the mind of the learned judge, who ought to have seen that unless the witness left there was anything suspicious, he would not have intervened with the accused and stopped him from proceeding with the minor girl. Full stop. It was further submitted that the court also introduced another extraneous fact, that is, that the witness did not belong to the locality. Full stop. Here it was submitted that PW5 had a cogent explanation for his presence, that is, to recover money lent by him. Full stop. In brushing aside the explanation, the trial court had erred in law. Full stop. It was urged next that the court rejected the testimony of PW6 and entirely discounted the extrajudicial confession made by the respondent. Full stop. Stanza. It was submitted that there is no blanket bar to an extrajudicial confession being considered by a court in the course of a criminal trial. Full stop. The learned APP also urged that the court should not have needlessly doubted PW6 statement about the respondent having committed the crime to him. Full stop. In this case, The prosecution is based on circumstantial evidence, full stop. It is a settled position that a criminal court can record a conviction in a case based on circumstantial evidence only when all hypotheses inconsistent with the innocence of the accused is ruled out, full stop. The court, while dealing with circumstantial evidence, held that onus was upon the prosecution to prove that the chain is complete, full stop. Stanza. The main legs on which the prosecution rests its case are that the deceased was last seen in the company of the accused and that he had extrajudicial confessed to having committed the crime, full stop. To establish the last seen theory, the prosecution relied on PW5 testimony, full stop. He claimed to be known to the deceased's father and having noticed her in the presence of the accused on the relevant date, full stop.